No, hardline kadar 5 kopya.
Hi everybody, how are you today? Sorry it took me a minute to get on. How's everybody doing? Just see here.
Good.
Hey there. All right. We're gonna go over lease agreement today. I see we have a bunch of people in the house. Hopefully you took the contract to lease class with Marvin just a few, I guess it was like 2 weeks ago, maybe. His rules of engagement for me is you're currently all muted. If you have a question, feel free to unmute yourself. I will stop from on occasion to answer any questions. But again, feel free to unmute yourself if I'm on a particular topic in the training that you want to further clarify, or if you have further questions, right? So don't feel bad about that at all. I'm gonna go ahead and share my screen and pull up one of my leases here. Give me a second. All right. Let's just go to residential lease. All right, can everybody see the screen and the shared screen that I have in front of you? Can everybody see the lease? Can somebody tell me if you can see the lease?
Yep, we can see it.
All right, perfect. Thank you for that. All right, so a few things that I want to go over before we even begin the lease agreement training. Obviously, I get a lot of questions about contract to lease versus lease and how those two work hand in hand. Now, keep in mind that when you guys negotiate your contracts to lease, and they get signed by both parties, that's usually a mirror of what you're going to be putting down into your lease agreement. So yes, the lease agreement is many more pages, but the contract to lease synopsizes what's about to get put into your full lease. Typically, the listing agent or the agent representing the property that's being leased prepares the lease. Okay, that's number one. That's how those two work in tandem or together. Second thing I get asked a lot is, can we do more than a 1-year lease? No, you can't do more than a 1-year lease. As an agent, you could only prepare 1 year at a time. If you're gonna do more than 1 year, that has to go through an attorney. So just keep that in mind. If you guys have someone that says, I want to rent something for 2 or 3 years, let an attorney write it up. Do not write that lease. Okay.
Of course.
Okay, perfect. All right. Jumping into this. The non-lawyer disclosure. Okay, this is nothing more than us certifying that we're preparing, or actually not preparing, we're filling out the lease that has been provided to us by the state. Is there someone that's,
I could write it down for you better, so you can see it better.
someone have a question?
Thank God
screen
we found
frozen.
somebody now. This is for medicine, and I will
It's
feel
just stuck
bad.
on the same page. I'm not sure we're supposed to be seeing it. It's just frozen.
Yes.
Okay, no, is there? I haven't moved it yet.
Okay.
Marco also hit mute all under the participants tab.
Okay, hold on.
I think my phone is on. Sorry, guys.
That's okay. All right, thank you for that, guys. Yeah, I haven't moved the form yet, so that's why you're seeing it right now still. As long as you can hear me talk, we should be good. if it doesn't move while I'm moving it, just let me know. But anyway, we're in the non-lawyer disclosure section, which is the first, and it's almost like the preface to the lease agreement. All we're certifying here, and the reason why they do this is to represent that you are an agent, you're filling out and preparing the lease or filling out the lease that has already been approved by the state of Florida, and you're just swearing to that you're not a lawyer. You know, although you're authorized to fill this out, you're not a lawyer. A little bit of on this non-lawyer disclosure is the landlord or tenant is supposed to check off whether they can read English and whether they understand. They do that so that they can't say later, I didn't understand what I was signing, or I didn't understand what I was doing. So hold on, I'm being told that this is not on the screen share. So you guys don't see a non-lawyer disclosure on the screen share right now? Because you should.
No,
No,
Huh,
it's just on your document page.
hold on, sorry. Where, let me see. Because I'm seeing the non-lawyer disclosure.
Yeah, Marco, if you hit stop screen share or stop share and just do it all over again and pick the screen, it should come right back up.
Jeez. Okay, hold on. Sorry about that. You see it now or no?
Yeah,
Can you see it?
yes, sir.
All right, sorry about that. So this is the non-lawyer disclosure section again. Sorry that you didn't see it in front of you as I was explaining it. But basically we're certifying here that we're not attorneys. We're filling out the lease on behalf of the landlord and or tenant, and that they're certifying that they also can read English, whether they can read English or not, and how this was prepared. So it's just a way for us to, you know, cover our butts in the case that they come back and say, hey, I didn't understand the lease. Well, here you're basically disclosing that you prepared it, they read English or understand English, and they're able to comprehend the full extent of the lease. That's all that first page is. Once you get into the residential lease, there's different ones. There's some that are for condo, some that are for single family. The one I have here pulled up is for single family. The condo is very similar. I'm sorry, this one is, this one is apartment or multifamily. Apologize, there's one that's single family that you can use that's very similar. So this one is the one that's utilized for multifamily and or duplex, other than duplex, including mobile home and condominium. You have your dates up at the top. Again, this is going to mirror right off the contract to lease. So you have your period of 12 months. Okay, usually a lease is a year long. Sometimes I see people put like 10/3/2021 and then they do 10/3/2022. Remember that the full year has to stop a day before the full year, 365 days. So wherever you start is typically the day before on the end date. That happens every now and then. Then you have property owners and name of people who are going to be leasing the property. Okay, so landlord tenant basically. Then you have their contact information, pretty self-explanatory. The property that's being rented, the zip code, and if you're including appliances, what appliances you're including. You can definitely go into more detail with that stuff. I've seen some people put, serial numbers and all that. I'm not for or against it. I just usually put whatever it is that I'm including. The list of furniture, if you have furniture that you're going to be including, my advice is to take pictures beforehand at the walkthrough and have them sign like at the bottom of that, furniture list, exactly what they're getting in the furniture section, for the landlord. Common areas, the tenant, they obviously have permission to use. Unless you're part of an HOA, which then, you know, they're gonna limit you or tell you what areas are common. So if you're in an HOA, the HOA rules and governs those tenants. Okay, keep that in mind. They usually get a copy of the bylaws if they're renting, at an HOA. So that way they know exactly what it is that they're being, or they can use and how those premises are being, utilized. So hours in a gym, let's say, pool hours at the pool, all that kind of stuff. Tenant shall pay for rent, the installments. Here is something that I think some people get tripped up on, because in the contract to lease, they put a total amount. Here is just telling you the installment that they're paying. So it's one time, like the 1 month, it's not the full. Okay, so just keep that in mind. The day of the month in which you start, if you're gonna be starting a lease, like on the 15th of a month, you know, some people wanna start on the 15th, the 20th. My suggestion is to prorate that. The way you would prorate it is on a 30-day calendar. So if someone is gonna be starting on the 15th, I would divide the full amount of the rent, okay, by 30, and that's gonna give you a daily rate. And then take that daily rate and multiply it by the 15 days and have them pay that as a proration in addition to the lease. That's how I would do that. Because otherwise, to get paid on the 15th of every month, you can do that, but in my experience, I think keeping it on the first, is a little easier. Tenant shall pay rent if you're charging taxes. In this section, what it's saying is if you're charging taxes for like a seasonal rent, then you have to add the tax to the lease payment, and then that number would go there. In this case, this wasn't like a seasonal rent, so we're not adding any taxes to it. So that's basically page 1 of the lease. Do we have any questions so far on page 1? Okay. We're gonna go to page 2 of the lease. Basically, when you have your contract to lease, section 5 is the most important here for when you're doing your you know, transpassing everything over into from the contract to lease. Section 5 is the most important. So here's where you're gonna have your security deposit. If there's an advance rent to be paid, that's where you're gonna put it. And then if you have other for like last month's rent, in the case that you want to charge first, last, and security. If you had a pet deposit due, you can put it there. Your late charges, you know, you can put all that in there. You can fill this in however it is, trespass from the contract to lease to this. So however that is, however that looks from the contract to lease and the agreements, that's exactly what's gonna go on section number 5. Section number 6 talks about security deposit and advance rent. Obviously, we know that the landlord has to hold the money in a separate interest or non-interest bearing account. However, if they're gonna make interest on the money, they have to disclose that to the tenant, and we're not talking about big interest, even the ones nowadays at a bank, or maybe 1% or something. But almost always a landlord has a non-interest bearing account, and they will deposit escrow money or anything that like security will be deposited in there. That's sort of like standard, and most landlords know that. Okay. You could have an agent for a landlord. In this case, I was the agent because I'm also the landlord in this particular lease. But let's say you have a CAM or a property management company, then you can go ahead and enter them in this section if they're the ones that are going to be doing all of the work and collecting rent and all that stuff for you. They are an extension of the landlord. So if the landlord, if they request an inspection of the property, the tenant has to look at that person as almost if they're dealing with the landlord. That's the whole point of having an agent. So pretty much anything that a landlord can do, the landlord's agent can also do. When it comes to leases. Because I've had tenants in the past call me and be like, hey, this guy showed up, said that he's, he needs to come in for an inspection. And, I don't want to let him in. And then I look at the lease and I see that it is the company that they've, put down as the landlord's agent. Well, in that case, they have to give the guy, the authority and the okay to go in. As long as it's reasonable. They got to give, I think it's 12 hours minimum notice in order to, enter into a premise of a tenant. Anything that has to be done or any notifying of the landlord, it has to be in certified mail, return receipts requested, and delivered to the tenant in the premises. I'm sorry, to the tenant. Has to be given to them in that manner. So a landlord can't just send a text and say, hey, I sent you the text, so you should have known about it. No. It has to be certified mail with return receipt and or delivered directly to the tenant. Okay, so that's one of the rules of engagement for landlord tenant. The use of the premises, I think we went over this a little bit. If there's an HOA, they're gonna supersede whatever's going on, even over the owner. But that's usually broken down into the bylaws. That is page 2 of the lease. Do I have any questions? Okay. Moving on. Page number 3. Okay, we're looking at in this section, we're gonna go over maintenance over here at the bottom, which is very important. But besides that, these boxes tend to confuse some people. So here's the way I look at these boxes. I read the sentence, landlord may adopt, modify, or repeal rules and regulations for the use of common areas and conduct on the premises during the lease term. All rules and regulations must be reasonable and in the best interest of the development in which the premise is located. And then I go, unless the box is checked. So I read it last to sort of, for me, it makes a little bit more sense. So let's look at the pet deposit. It says unless this box is checked. I say pet deposit has been paid unless the box is checked. So that's, people have problems with these boxes. That's the way I sort of tell them to read it. I tell them read what it's talking about first and then read unless the box is checked, because it sort of makes a little bit more sense. I don't know if any of you that happens to you, but it does to me, and it's happened to a few agents that I spoke to, and they're like, yeah, it makes so much more sense. Okay, so that means no smoking is permitted in the premises, correct? Unless the box is checked. So if you go back to it, like I said, it sort of makes a little bit more sense. That being said, a lot of this stuff is like very, self-explanatory, like the smoking, the pets. I don't think there's anything here that's going to really stall you guys out. The section number 9, I will say that I get a lot of people saying that the landlords try to get away with like putting everything on the tenant. So what you want to do here is obviously with some common sense, look at it. And if they're saying, okay, tenant is responsible for everything, that's a problem, right? That just means this landlord is trying to like, they're really trying to get over on you. So let's look at this for a second. Smoke detectors, landlord, extermination of rats, mice, roaches, ants, wood destroying organisms, and bed bugs. I mean, if you're leasing a place, you're not going to be putting a 10 on it, okay, to get rid of termites. It's obvious that it's landlord. Recently, I had an agent that, again, everything was checked off on the tenant side. Be very vigilant when you're reviewing what they send you back, because although this is 19 pages, I'll tell you the first 4 are probably the most important. What I think is 18, 17, I don't know. But the first 4 are the most important of the whole thing. So if you pay attention to page 1, 2, 3, and 4, I think you're going to be fine. But keep an eye on this stuff because they're really trying to get over on your tenants lately with these leases. Okay, and keep in mind that if they sign this, then everything is going to be reverted back to the lease. So that means if later on down the road, the landlord says, well, that's your problem, I'm not fixing this, and you come back here and it says, well, it's tenant responsibility, you don't have a leg to stand on. So do yourself the favor and really look at this when they send it back to you. Obviously, it says tenant's responsibility, if any, indicated above shall not include major maintenance or major replacement of equipment. Again, most of the time, those kind of things are gonna go back to the landlord. They're not things that you want to throw onto the tenant. In this case, here, landlord shall be responsible for major maintenance or major replacement of equipment, except for equipment which tenant has accepted responsibility for major maintenance or major replacement in the previous paragraph. Major maintenance or major replacement means repair replacement costs more than $100. So I like this part for landlords and for tenants, because that sort of sets a line of where things are. So you're not gonna get a call from a tenant saying a light bulb went out when they could just replace it for a few bucks. So anything under $100, typically a landlord can go to the tenant, if they fill this out here, can go back to the tenant and be like, hey, look, that's basically that's your deductible on the property. You can pay anything under 100. If it comes to more than that, then I'll pay for it. All right, so that's just, again, I think that's a good provision that they have in place there. Any questions so far on that page? Any questions?
No.
Okay,
Marco, I have a question.
yeah,
Which one of those boxes are appropriate for the landlord to put as a responsibility of the tenant? Like, are there any, if most of them are checked off that it's the landlord's responsibility, but a
well, I
couple
think
of them
this
are the
one, I think
tenants, like,
this
which
one,
ones would be okay where you wouldn't fight it?
yeah, I think this one is pretty good. Like, if you look at it, clean and safe condition of the outside area. Well, the landlord's not gonna be there. If he turns over the property clean and the guy and the tenant, you know, starts throwing trash outside, that should be on the tenant to keep it clean. You know, garbage removal,
Got you.
again, tenant. In this case, we negotiated that the tenant was gonna take care of lawn. You know, heat, I think that should be landlord, air conditioning landlord. Furniture, I have under tenant because they're bringing in their own furniture. So, I mean, that's not on me. Appliances, I took care of. Fixtures, I'll take care of. And then heating and air conditioning filters, that's a big one because you're not living there. So again, you're not gonna go there, you know, once a month to go change a filter when they're living there and they can do it themselves. I think that's one that's very appropriate to give to a tenant. And I think that no one's ever given me a hard time about that. So I think these are pretty good as far as those things. Okay. All right. Let's move on. This is gonna be page number 4. Page number 4, like one of the really important things to keep in mind for page number 4 is gonna be utilities. Service member is important, but we're not gonna run into it. Well, we might, I shouldn't say that. You could run into it. Access to the premises, prohibited acts by the landlord, that's important, and I'm gonna go over a few of those. Casualty damage, defaults and remedies, assigning and subleasing, especially in the day and age of Airbnbs and all that. You know, subordination of the lease, liens, and risk of loss. Some of this starts getting into some of the law part of a lease. So, you know, I'm not going to tell you that you need to know this like the back of your hand. In fact, these lease agreements, like I've already told you, have been already done and prepared by, you know, an attorney and approved through the state of Florida for us to use as agents. So a lot of this verbiage, don't get lost in it. Like, I don't want you guys to get too lost in what it is. I'm just trying to give you a little bit of a basis of what it means. So if a client says, hey, you know, what does it mean when it says service member? I'm reading this because I was part of the Army or Marine. What is it exactly does this mean? At least you can give them a little bit of a little bit of information. So let's go and let's start at the top of this. It says here, tenants required maintenance at all times during the lease term, tenant shall. Okay, when it says shall, there's no gray area with shall. Shall means that it is. Comply with all obligations imposed upon tenants by applicable provisions of building, housing, and health codes. Keep the premises clean and sanitary, remove all garbage from the dwelling unit in a clean and sanitary manner. Keep all plumbing fixtures in the dwelling unit clean, sanitary, and in repair. And use and operate in a reasonable manner all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities and appliances, including elevators. Okay. Just keep in mind that, you know, during this lease term, that's why the page prior was so important. If there's ever a dispute, it's always going to come back to that. And so you always want to make sure that these things are clear when you speak to your tenant about the lease. Okay. So that's definitely one that I would, you know, want you guys to always keep in mind, is it's always going to come back to this lease. In an argument, whether they want to get out of it, or they say that this is inhabitable, the premises is, you know, not livable, it's all going to come back to this lease. So just make sure and do yourself the favor of reading through that page 3, especially when you're doing it. Okay, I can't emphasize that enough. Tenant shall pay all charges for hookup, connection, and deposit for providing all utilities and utility services to the premises during the lease term, except. This is actually on your contract to lease on page 2 at the top. It says it there. What it's saying is, what is the tenant responsible for hooking up? What is the landlord responsible for hooking up? Okay, so it's just going to come off your contract to lease. The service member section 11, you're not going to use that a whole lot. However, if you do rent to someone that's in the military, and for whatever reason they get activated, or if they're going to leave and, you know, the lease is up in the air, just keep in mind that there's rules and regulations protecting them, you know, to break a lease. So, you know, it tells you here the section again. I don't have a law book in front of me, but that's basically what those terminations are. And those provisions can be found, you know, in that subsection. So that's all that means. Landlord's access to premises. They may enter in the following circumstances to protect and preserve the premises. Now, I've had landlords in the past tell me, "Oh, I got to get into this property, and you know, the person, you know, I feel like there's a danger in the premises." And then I'm like, "Wait a minute, what's the danger?" And then I find out that they haven't been paid rent in 2 months. That's not a danger. Okay, like they can't make up something happening in the premises to try to go in. It has to be where there's anybody reasonable will say, okay, I can see how that can be an issue. All right, so obviously the landlord goes and checks on the property, smoke coming out the back window. Obviously he's going to call 911 hopefully, but nonetheless, he bangs on the door, nobody opens, he can go into that property. Okay. After reasonable notice to tenant at a reasonable times for the purpose of repairing the premises. So let's say I did a contract, or I did a lease, and I know that I needed to repair, a plumbing fixture under the sink. I can tell the tenant, hey, I need to go repair that thing under the sink. It's gonna, you know, take only about an hour or two. I need to get in Saturday at 6 p.m. Well, that's reasonable time for you to do that. In those cases, you can go into the premises as a landlord, okay? To inspect the premises, make necessary or agreed upon repairs, again, going back to repairs, decorations, alterations, or improvements, supply agreed services, or exhibit the premises to prospective or actual purchasers, mortgagees, tenants, workers, or contractors. You have the right to sell a property as a landlord. So, being that you have a right to sell the property, if you put it on the MLS and you got people that you schedule showings, you and the tenant should agree on a time to go in, but the tenant can't be like, hey, I'm not letting anyone in. This lease basically is telling you that, you know, the landlord has the right to go into that property especially if he's gonna be selling it. Excuse me. However, that also doesn't mean that you can go in there with, especially in this market, you're gonna go and flood the place for 15 hours in the day and say, I've got 30 people that wanna see it. You know, it has to be reasonable. And reasonable is giving them notice and setting up those appointment times. What I've told landlords in the past is if they have a tenant, take 2 or 3 days out of the week that are set times and set your showings during those times. Agree with the tenant. It's never been an issue. Tenants have always been amicable with that. And however you guys want to work that out, that's up to you, but that's some feedback of how I've done it. Obviously they can go in with tenant's consent in the case of an emergency. If a tenant unreasonably withholds consent, so again, that's again saying, well, you have the house for sale, I don't care, you're not coming in. Well, that's unreasonable. If the tenant is absent from a premises more than 1/2 of the rental installment period, a 30-day period, which means if they're gone for more than 15 days, okay, the landlord may enter, okay, that premises. Again, you want to have the tenant's consent, but the landlord can check and make sure that the premises is secure and that everything's good. Prohibited acts by landlord, that's a big one. Like, again, I've had these people say, I haven't been paid rent in 3 months, I'm gonna cut their FPL. Well, you can't do that. There's laws that say you got to keep running water, electricity, and everything habitable for the tenant until you go through the proper channels and get an eviction. You can't just go out there and be a commando and be like, oh, I'm gonna get rid of this person, I got it. Shut their electricity off. You can't do that. You'd be surprised, and some of you may know people that have, you know, thought of doing that, can't do it. All right. Any questions to this point? Okay. We're going into casualty damage. If the premises are damaged or destroyed other by the wrongful or negligent acts of the tenant or persons on the premises with tenant's consent, so that to use the premises is substantially impaired, tenant may terminate the lease within 30 days after the damage or destruction has occurred. Basically, a good example of this is the landlord sends, I don't know, an AC guy to go fix the AC. All of a sudden, AC is broken, can't get it fixed. The guy made 3 or 4 holes in the wall that are now open and exposed, and there's no end in sight as to when this is going to get fixed. That's damage that wasn't caused by your tenant. So in that case, a tenant may terminate the lease. They have to go through the proper channels of doing that, which is obviously notifying the landlord. Reasonable time is 30 days. So they can get out of that though. So if you have that situation arise where a tenant is saying, look, this place is just inhabitable, then the question becomes, what's inhabitable? No AC in Florida, to me, I would consider that inhabitable. Defaults remedy. Should a party to the lease fail to fulfill the responsibilities under the lease or need to determine whether there has been default of the lease, refer to part 2, chapter 83, blah, 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 and the Landlord-Tenant Act, which contains information on how defaults and remedies. A copy of the current version of the act is attached to the lease. This is basically, you go, you do a lease, or they send you a lease, escrow deposits due, all of a sudden your tenant is not complying. So all this is saying is that there is a section that's made for the like not performing on the lease, basically. And I've seen this happen as to even last week. I had someone that was like, oh, I'm not going to give a deposit. And I had to explain to them, look, you could not do that. But then there are ramifications that come with that. Sometimes they care and they move on. Sometimes they won't care and they'll be like, all right, just whatever. If they want to keep my deposit, it is what's going to be. So all that is saying is that if you default on the lease, whether it's at the beginning or in the middle, that there's remedies that and obviously things in place to protect the landlord and or the tenant. Assignment is subleasing. In the day and age of Airbnb, this is happening a lot. So there's people that will put out a lease and they'll say they'll pay the full amount of a lease, and then they'll pay big attention to this section here. Because again, unless this box is checked, okay, so let's go back to this. Forget about that. Tenant may not assign the lease or sublease all or any part of the premises without first obtaining landlord's written approval, unless the box is checked. So obviously, the regular lease is written that they're not supposed to sublease, okay? Now, if they are allowed to sublease, then this box should be checked. And so if you have a person that's doing a lot of that, and there's people that are doing this over and over again and making money on it, and it's fine, is the subleasing with Airbnb especially, they'll put in a lease for $2,000 and they'll sublease it for, you know, $3,500 a month on average. So they're making a little bit of money. That's fine, but that box has to be checked. Okay, so you may run into that. Let's go to the next thing, risk of loss. Landlord should not be allowed any loss or reason by damage, theft. Obviously, if your place gets burglarized while you're living there, that's not on the landlord. You know, it's tenants can get renters insurance. They can do a few things to protect themselves in those cases, but it's not solely on the landlord or even on them at all, should something get stolen. Subordination, the lease is automatically subordinate to the lien of any mortgage, encumbering the fee title to the premises from time to time. So what it's saying is that it takes second place to any lien that is on the mortgage, encumbering the title. And to put that in plain English, all that means is that if they say, I own a property and Bank of America is the lien holder, and all of a sudden I start going through foreclosure proceedings, that is going to take precedence over the lease that's in place. So they don't play by the same rules. Basically, their rules are they own the property. If the person is going through default or lien, that's going to take very first position over the lease. The next part talks about liens. The interests of the landlord should not be subject to liens for improvements by the tenant, as provided in section 7310. Again, going in a little bit of law. Tenant shall notify at all parties performing work on the premises at tenant's request that the lease does not allow any liens to attach to the landlord's interest. Okay, what that means, and to break that down in plain English, let's say the tenant decides, I want to do a pergola in the backyard because, you know, me and my wife, we like to sit outside and have coffee. Now, all of a sudden, they do the pergola, okay, and the tenant, although they set up the work to be done, the guy that built the pergola puts a lien on the property based on the tenant's request to do the work. Well, it's not going to allow it to attach to the landlord's interest of that property, meaning the tenant's going to be on the hook for it. So that's going to be the tenant's issue, not the landlord's. All right, that's a wrap on page 4. Any questions? Okay. Can you guys hear me okay still?
Yes.
Okay,
Yeah.
perfect. Okay, great. If there's any questions at all, and even if something comes to mind that you're hoping to cover here and we haven't gotten to it yet, just spit it out so that way when I do get to it, at least I know that it's been covered. No problem at all. Just unmute and ask and then mute yourself back so that we're good. All right, approval contingency. This is obviously when you are dealing with HOAs and things like that, they need to get approved by the HOA in order to be a tenant in a particular place. We all know that. If they don't get approved, there's no way that they're going to become a tenant. So that's pretty self-explanatory. Renewal and extensions, being that we could only write these leases or fill them in for a period of 1 year. If let's say you have the same person stay in the same property for the following year, it becomes a brand new lease. Even if the security deposit stays in place, that security deposit is a new deposit. So yeah, I can transfer, or the landlord could say, yeah, I'm going to do an extension, but it's still a new lease. So you can't just use the same lease and put on there, extended a year. You can't do that. You gotta prepare a new lease, and it has to have another year on there. So it's gonna be a brand new lease. Again, if you're gonna do more than 1 year, it has to go through an attorney. Lead-based paint, obviously before 1978, there's disclosures involved. Everybody pretty much knows about lead-based paint and the dangers of that, and how or not it could be, you know, take or come into a play with a property. They basically have you fill it out more, again, to cover our butts and cover everybody's butt that's involved. But you're basically picking one of these, and then the lesser and the leasee are signing at the bottom, wherever it is that they filled in at the top. So it's not rocket science. You read that, you pick the one that's most appropriate, and you know, you get it signed. Attorney's fees, any lawsuit brought to enforce a lease under applicable law, the party in whose favor or a judgment decree has been rendered may recover its reasonable court costs, including attorney's fees from the non-prevailing party. That's a big one, because if they get into litigation over the lease, and let's say the landlord wins, well, not only is that person going to be on the hook for the money that they were fighting or disputing about, but the tenant's also going to have to pay the attorney fees. So that can end up being a lot of money. So when you start talking about people non-performing on the lease, especially at the beginning, please explain that to your tenants. Most of the time I see it with tenants, because typically if a landlord has a property that's being rented, they want it rented. But in today's market, I'm noticing a lot of tenants putting multiple offers on, and I understand why, onto different properties. And then let's say they got one and they got a contract to lease signed, they give the deposit, then a day and a half later, a better one comes about, and now they want to move on that one. And let's say they can get that one. Well, at some point, you know, your tenant needs to be aware that these things are binding. It's not like they could just jump and get out of things, you know, that simply. So just be that voice of reason for them to say, look, you do have a bird in hand. You did want this one. I understand if you want to shift. I'm not saying we can't try to get your deposit back, but understand these are signed documents. It's not like you're signing and you can break it however you want. It's not the way this works. So just keep that in mind. It happens a lot. I'm sure you guys have seen it already with people renting. They want to put in offers all over the place. Well, when you get one signed and executed, my advice is don't execute any others until you resolve the one that you've got signed. Okay. All right. Tenants, personal property. Basically, tenant agrees that upon surrender, abandonment, or recovery of possession of the dwelling unit due to the death of the last remaining tenant, as provided in Chapter 83 for a statute, landlord shall not be liable or responsible for storage or disposition of tenant's property. So basically, if somebody passes away in the property, there's two people, and the lease is up, and the person can't be like, oh, that was my wife, but she passed away, so you could keep it. No, I mean, you gotta get rid of it. It's yours, and therefore you have to take care of it. You know, that's basically what that's saying there. Any questions to this point? Any questions?
No.
Okay. Early termination, liquidated damages. I always put this as 2 months. It's the max. That's basically in the case of a default, in the case of a non-performance at any point of the lease, then, you know, the landlord can go after what's the liquidated damages of the rental agreement. Let's play this another way. Let's say the landlord doesn't perform on the lease. I don't know what that would mean. Like, I guess, you know, in the case where, again, it's uninhabitable, they, you know, can't reside there, whatever, the tenant wants to break it. You know, keep in mind that the tenant can do that with the 30 days and all that, and they're going to be able to get out of that lease. So in that case, there is no early termination fee. Like, it's not like a landlord could be like, well, the AC broke, I'm not fixing it. The tenant says, okay, well, then I can't live here, leaves, and now the landlord says, well, wait a minute, you owe me $5,000. That's not what that means. So if If you terminate the lease as a tenant because of an uninhabitable situation, this is not gonna go along with that. This is only in the case that you break it and the landlord has, done everything he needed to do. Okay. Now we're moving on again. Now this is where it definitely gets into everything is law. From like 8, let me see where it is, from like 8 to, I think it's almost to the end. Yeah, all this. I would like to, instead of it being like verbatim and me reading this, because we could all read, can you guys go through this? Do me a favor, go through page 12. No, let's go through page 8 through 18. Okay, 8 through 18. Real quick, just sift through it on a lease agreement. And if there's anything that you definitely want to cover, I can stop there and do it, because otherwise this becomes is just jargon, is law jargon. So we can go through the topics and then you guys can tell me if you have a particular question on that topic. Does that make sense? Okay. So we'll start with page 8 here. See, because it goes into definitions too. I mean, it's like, these are all the definitions of what things mean. These are actually good to know. If you can, get look at those definitions, that's fine. Obligation of good faith, unconscionable rental agreement or provision, rent, duration of tenancies, prohibited provisions and rental agreements, deposit money or advance rent, duty of landlord and of tenant. This is actually a good one. Let me break it down a little bit easier. So you guys, I think that's an important one, the deposit. The rental agreement and or as an advance rent on the next immediate rental period. And it shall either hold the money. We talked about this, holding it in the non-interest bearing account in Florida or banking institution with that benefit, hold the total amount in a separate bearing account other than when they're receiving collect interest. So your deposit should be held separate from where they're just collecting rent, for sure. And again, most landlords know that, because they don't want any commingling of money, where your landlord is utilizing your security deposit at some point, and then at the end it's like, well, I don't have your security deposit. That's why they put this into place. It's a way of protecting the security deposit. So security deposit, although you pay it to landlord, they should separate that from where they're receiving their payments for the actual lease, as to not commingle the funds. Okay. 30 as a receipt of advance, so you're gonna give a written notice to tenant.
Marco,
Yeah,
I have a question. Sorry to
yeah.
interrupt.
Go ahead.
So if we get a listing for a rental, is it our responsibility to educate the landlord on all the legalities of like how he has to keep the money?
You do want to have that knowledge, and you do want to at least tell them if you think that they don't have that knowledge as you go over your lease, or even prior to when you get the listing. Because
Okay.
at the end of the day, here's the great thing about why that non-lawyer disclosure on page 1, which happened years ago, right? It feels like that we spoke about that. But that non-lawyer disclosure is so important. I'm gonna tell you why. You're not on the hook if your landlord doesn't do it correctly. Does that make sense?
Yeah, sorry, I missed the beginning of the training, so you might have already covered that.
Oh, okay. So the non-lawyer disclosure basically it pledges and it confirms and certifies that we're not attorneys. So all we're doing is filling out this lease, okay, on behalf of the landlord, let's say, but we're not attorneys. So everything that is enclosed and encapsulated in this lease agreement is the landlord's responsibility. So let's just play devil's advocate that your landlord says, well, you never told me that I had to keep it in a separate account, so I'm gonna sue you. Well, no, he can't. Because in the lease agreement, which he signed, it's telling him how he has to keep it. So although it's good information to give them, don't feel like you're on the hook if you don't, and they end up not doing it and holding the money correctly, if that makes sense.
Yeah, thanks.
Okay, perfect. Good question though. Where was I? The landlord shall in lease agreement 30 days of rent, get rent to the tenant, which includes disclosure of advance rent. Yeah, so they have to disclose everywhere that, you know, whether it be through receipt, most of the time it's through a receipt, you know. That's the reason why we upload receipts into our transaction desk for escrows and things like that. They're supposed to, you know, disclose to the tenant how the money's being held. Truth be told, a lot of them don't. I would say 75% of our landlords out there are not doing this. And I mean, obviously they can get in trouble should it come to head, but it rarely does. So again, but they can't say they didn't know, it's on here. So it's not like they can deny that. It's not something that they can't deny knowing. State whether the tenant is entitled to interest on the deposit. If they do put it in an interest bearing account, the landlord and tenant at the beginning have to stipulate if the tenant's gonna get interest from that or not. I've never seen this come ever in 13, 14 years. I've never seen ever a dispute over interest on a deposit ever. So I doubt that anyone will, but in the case that you do, you know, it's good to know, and that's why it's good to disclose where the money's gonna be held. So keeping that in mind. This is contain the following disclosure. Your lease requires payment of certain deposits. The landlord may transfer advance rents to the landlord's account as they are due and without notice. When you move out, you must give the landlord your new address so that the landlord can send you notices regarding your deposit. The landlord must mail to you notice within 30 days after you move out if the landlord intends to impose a claim of your deposit. So if you leave the place trashed, and if your tenant leaves the place trashed, the landlord has 30 days to notify them, okay? If you're not replied to the landlord stating your objection to the claim within 15 days after you receive it, then the landlord will collect the claim and must mail you the remaining deposit, if any. This is important. I think this is a good one to go over because it could happen, and it's more likely to happen than pretty much any of this other law stuff. You have a tenant, they have destroyed the place a little bit according to the landlord. So again, you did walkthrough, everybody signed the little walkthrough form that, oh, it looks good, no problems, blah, 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 blah. Now the lease is up and the landlord calls you and says, hey, we need to go and check the house to make sure everything's okay. You go in there and now there's a ton of shit broken. There's holes in the wall that they left and the landlord's pissed. So obviously he's going to tell you, I want to go after their deposit. Okay, well, there's a way to go after the deposits. All right. First, I always start this off by the same way that you communicated throughout your lease. So if the tenant had an agent, hey, look, I just did the walkout with my landlord. He's not happy. Your people destroyed the place. He's looking to keep he wants to be compensated with the security deposit. That is not official notice, but that's the way that the real world works, I guess. That's the way you're probably going to hear it, is through the other agent or through the tenant or landlord. So you go, you ask the tenant, hey, look, you destroyed the freaking place. The guy wants $1,500 of your security deposit. All right, yeah, it's true. I destroyed it. Let him keep it. In which case, now you're going to get the release of escrow that we all get signed when we have money in escrow, that the landlord and the tenant are going to sign and agree to turn over the money back to the landlord. That's the easy way to handle that. Okay, if you think that it's going to be an issue, so the same scenario happens and the tenant says, screw you, I left that place impeccable and I want my security deposit back. Okay, well, now the landlord has to give notice to the tenant officially, okay, through certified mail or through delivery or signed mail that they want to keep, they intend to keep their security deposit. Now, when the tenant receives that, it's not like he could just look at it and be like, ha, I'm not letting him keep that and not respond. If he does that, then there's a 15-day clock that starts at that point. So now you've given the notice to the tenant. When he received it, 15 days start. When those 15 days are up, if he did not respond, the landlord can now keep that deposit. Okay? If the tenant responds back within the 15 days saying, well, now I'm making a dispute and I want to go ahead and I feel like I left the place impeccable and I don't want you keeping my security deposit. And he responded everything on time. So now it's going to go into an escrow dispute, which more than likely is going to turn into a civil lawsuit between both of them and the claim of deposit. Okay, that's basically how that works. Does that usually get to that? Very rarely. I've seen it where they both agree, we'll split the security deposit. I'll fix up and patch up the walls and paint, and I'll give you half your deposit back. Or the tenants really do know that they destroyed the place and they're like, I don't care. I know I totally messed it up and I don't have time to fix it or go back and do anything. So those are the two most likely scenarios that you're going to face. Is very rarely, and I say that with, a little bit of, I want to be careful saying that, but rarely is going to get to that. Okay. Any questions on that?
No.
Okay. We're going to go into the topics: history, disclosure of landlord's address, landlord's obligation to maintain the premises. I mean, that's a decent one. These are all very, there's nothing, no trickery here. Like, it's very black and white. I don't even think that it's something that would even confuse anyone here. I mean, you read it and it's like, there's nothing to know about this. I think that for many of you, the lease agreement, you're probably wondering where the problems are, or what you need to know, sort of. And that's what I'm trying to give you. So I don't want to get you lost in the sauce and all of this stuff, honestly. Like, I feel like you got the first 4 pages and we went over that with the premises, the non-lawyer disclosure being the first one, second one being the dates that you're renting, tenant information, the very next page. Oh, I'm sorry, the rent and the type of payments, whether it's going to be monthly, at what day of the month, that's important. Second page, section 5, very important. That's going to be the breakdown that's going to pass over from the contract to lease. Security deposits, that's important. What we talked about with the way the landlord's going to hold it, the use of premises, depending if it's an HOA or no HOA. It dictates how they're going to use that. And then the maintenance on section 9, page 3. To me, if you've picked up all of those, there's nothing you're going to write into your lease past, probably page, this is the lead base. There's nothing you're going to write into your lease past this one, which is page 7. Like, you're not even filling in anything else past page 7. Everything else is there for the explanation of your tenant and or landlord. So, like, for me to just read it verbatim to you, I think it's going to lose you a little bit, and I'd rather not do that. I'd rather you guys know that if you got through page 1 through 7, where we fill out, those are the most important. And then these areas are more just law. Like, again, it's just giving your tenant and or landlord explanations of the lease. I'm more than happy to give you my take on any of these, but truth be told, when I get a lease signed, once I get to page 7, I'm rarely looking at it. The only time I'll go back to it is if someone comes back and they actually took the time to read 18 pages, which I doubt, and they want to like talk about it, and in which case it's very black and white anyway. So I think that for you guys, again, page 1 through 7 are the most important, and those are the things that are fillable. So if you think that you've gotten enough info to get through those, then I've done my job, and I don't think that there's any reason to go into those law terminologies. You guys agree?
Yes.
I'm leaving my number here on the chat. So you guys can lock it in, because you might get it, you might get a lease or your first lease or whatever. And you say, hey, Marco, I did take the class. I sort of forgot how this or that goes. I'm more than happy to look at even your lease and your situation and talk about it and give you my best advice to that. So don't feel like you can't reach out. I don't care what branch you're from, your lifestyle at the end of the day. And so we help each other out. So feel free to lock my phone number in. And again, leases, the contract to lease is basically the only thing you're filling out going into your lease. I would say the only difference between the two really is that you're filling out a little bit more detail on your lease, page 1 through 7, but it's not earth-shattering, stuff that's really crazy. Pay attention to this section, which was 9, like I told you, because what I have seen lately, again, is that a lot of agents, especially representing landlord, are trying to throw everything onto the tenant, and that's not fair. So make sure you read it. And even if your first one comes through and you want me to look at it, I'll look at it with you. It's never a problem. Okay. I think
Thank
that's
you.
gonna be it, unless anyone has any other questions or anything you want me to cover with you.
Can you send us the sample of this lease?
Yeah, I can. If you let me think, what's the best way to put this? Send me your email address to my text message if you want to receive it, and I'll send it to you. How's that? Just send me a text with your email address on the number that I provided in the chat, and I'll be more than happy to send you a copy of the lease. And don't forget, guys, even more important than that, LAR Cloud has an actual copy. Let me see if I can see that real quick. It's
I
already,
seen that there's a copy there. I wanted to
Yeah.
know about that. There's one that's a sample. It says condo, and then there's another one that says single family.
right, the one that we reviewed today was the condo one.
Okay.
Okay, but
Yeah,
they
it's there. I just downloaded it last night, so it's there.
all right, well, there you go. So this is even better, to be honest, because it's filled out like in red, and even where you can't miss. You can't miss if you go by this. But if you have someone sending you a lease and they want you to sign it and you haven't had any experience with leases, hit me up, send me the lease, I'll look at it for you. All right. All right, everybody. Thank you so much for joining today. I really appreciate it. And again, best of luck out there. And if you need anything, reach out.
Thank you.
Thank you.
Okay.
Have a great day.
Okay. Bye.
God bless.
Thank you.
Yep.